Susie, I want to talk to you about, a loved one passed away and I have no idea where to start. Where would you advise somebody to start?
One of the first things you're dealing with is the obvious immediate issues as far as, burial or cremation instructions and getting those kinds of arrangements made. And you're also in a fog and you're in shock. And those are really tough times to be able to try to triage everything. If you can, find where the documents, if they have documents, are located, that's extremely important. And then I would say, call an attorney who specializes in the area of probate to guide you through that process. Finding original documents is sometimes challenging, but if you can find them, they are very important to have.
Let's talk about a scenario where we found two different wills. So where do we even begin?
Yes, that can be very challenging. So you are in a situation where there's going to need to be what's called a formal probate. And typically, the most recent will that's been done is the one that's effective, because usually there's language in there that says it revokes any prior wills that have been made. But occasionally you will find older wills that may not have that language. They may have been done close in time, and there's going to need to be a determination by the court sometimes on what is the actual valid will. So really it's a matter of getting probate counsel involved and making sure those wills are located and they're filed with the court and they're admitted to probate. And so that's where things get a little bit sticky, and but we do see it happen from time to time. That's the other reason why it's really important if people do a new will and say they had a will from 20 years ago, that they make sure and destroy the old will prior, or, when they go to do their new will, so that that old will isn't lying around where it can confuse people.
Susie, can we talk a little bit about, adult children have inherited a house, mom passed away, dad passed away, perhaps 10, 15 years ago. And they think, the process is going to be very straightforward. What would you advise them to consider in a scenario like that?
So one of the things that we often run into is maybe if one of the parents passed away some time ago and there was never a probate opened, and maybe the surviving spouse never went to see an attorney just to make sure everything passed the way it needed to, is sometimes, especially with older deeds, mom and dad may have been listed on there with just their names, Bob and Mary Jones, but there was no other designation. And in Colorado, if it's listed like that, the default is that mom and dad own the property as tenants in common, which means they each owned 50% of the property, but upon dad's death, for example, if he died first, his share did not automatically pass to mom, but everyone has just assumed that happened. And now, years later, when mom passes and the family is trying to sell the home and they suddenly realize, oh my gosh, mom didn't in fact own 100% of the home, that you might end up having to go back to open probate for dad to pass that interest to mom's estate, so that mom's estate can then pass it to, can transfer the property to someone else. So it's one of those sort of hidden, landmines that people sometimes don't know about until years down the road. So I would say one of the things people could do is just if, say one parent passes, probably a good idea to go see a probate attorney and have them check the deed on the home, just so it's really clear what happens next.
So Susie, there's a lot of different deeds out there. Can you describe briefly what a beneficiary deed is?
Sure. A beneficiary deed is a deed that I would want to say, give my son my home when I die. And it's a deed that I would actually prepare now and I would sign now. It would actually be recorded with the county where I live, but it has no legal effect until I actually pass away. But then title to my home automatically transfers to my son, and he also would get the step up in basis similar to as though he inherited the house. So they can be really beneficial. beneficial. But one thing people need to be cognizant of is if they need Medicaid eligibility, then and they have a recorded beneficiary deed out there on their home, they're likely going to need to revoke that deed, because you can't have a recorded beneficiary deed on your home if you are applying for Medicaid long-term care in Colorado. Otherwise, your home is counted as an asset against you for purposes of eligibility. But if that is not an issue, beneficiary deeds can be a possible option.
I think there's a little bit of a common misconception out there that a quitclaim deed is equal to perhaps like a beneficiary deed, and that it sort of holds the same weight or does the same thing. Can you clear up that common misconception?
Sure. So quitclaim deed is a transfer of a current interest in real estate to someone else. So like if I were to quitclaim you an interest in my home, and you and I were going to become joint tenants with right of survivorship, for example, in my home, and I've given that to you now while I'm alive, then it has some gift tax implications. It also could potentially have estate tax implications later on. And capital gains issues, because I've given a current gift to you during lifetime. Whereas a beneficiary deed is a deed that is prepared now, recorded now, but it has no legal effect until after I pass away. So there is a better tax advantage to a beneficiary deed if the intent is for me to pass that property on to someone once I'm gone. The other issue with having someone deeded on to my home now through a quitclaim deed is now we are joint owners and we are jointly responsible for that home. But if I get sued or you get sued and there's a judgment, that judgment could be recorded against my home that I've put you on. So it can basically unintentionally create some situations that people don't foresee.
So Susie, why don't you talk to me a little bit about being an adult child of an aging parent and, the concept of like preventative planning?
Sure. Yeah. So it's a difficult issue a lot of people are dealing with. And I think the biggest thing is to be able to have a conversation with your parents and find out, have they met with an elder law attorney or an estate planner? Do they have a will? Do they have medical powers of attorney or financial powers of attorney? And most importantly, where are these documents? Where are they located? Parents might be not willing to talk about, well, who's going to do what, although it's a great idea. And if it opens up that conversation and that opportunity for some transparency, that can be so helpful, so that if there is an emergency or a sudden medical event, then family members know who to turn to. They know where the documents are located, and they know they have the authority to make decisions if necessary. If there aren't those things in place, then unfortunately sometimes it ends up where the family members might have to petition for guardianship or conservatorship of mom or dad if they've already lost capacity and lost the ability to make those decisions. And so sometimes people come to us a little too late after they say, well, I want my mom to be able to do a power of attorney, but mom has advanced dementia and it's too late for that.
So let's talk through a little bit of a scenario where a loved one is still alive and perhaps they're showing some decline like cognitively, and they need to perhaps move on to the next stage, long-term care or whatever it is. What's the next step on selling the home, selling assets to fund those types of endeavors?
So I think you really have to start with a care plan first and try to determine what is the care plan for this individual, and does this person have a medical power of attorney? Do they have a financial power of attorney? Do they have something in place where someone can help them with decisions if they are unable to make those decisions themselves? And then it's going to depend on what those powers of attorney say, and are they thorough enough where it allows authority to sell a home if necessary, for example. And so I would say, really it's important for, especially if you're the child and you're the caregiver, to, get mom or dad to a qualified doctor and have them fully assessed to really understand what their current diagnosis is, what their prognosis is, and then possibly bring in other professionals like geriatric care managers to help with a care plan. Then, also making sure that there is legal authority there, either through powers of attorney or potentially through a court-appointed guardianship or conservatorship to make some of these decisions, whereas guardians would help with decisions about placement if they were, say, to move into a skilled nursing facility, and whereas a conservator would have the authority to possibly sell the home and make those financial arrangements. So it just really is going to depend on what legal documents that person has in place, or what the care plan is going to call for.
I briefly want to chat about what the difference is here in Colorado between a conservator and a guardianship. Can you define those roles?
Yeah, great question. So in Colorado, a guardian is the person who's appointed to make health, safety, welfare, and medical decisions for someone if they're not able to. And there has to be a finding that that person is incapacitated before a guardian can be appointed for them. But the guardian's role is really around that care and day-to-day, health decisions and that sort of thing. A conservator, however, is appointed to manage the assets that belong to someone who's not able to manage those assets for whatever reason. And so a conservator's role is a little bit different than a guardian in that they are, paying day-to-day bills, they may be managing real estate, they may be managing investments and so forth. They may end up having to sell the home to pay for care. So it just depends on, what that person's assets are and what their needs are.